I am Jules Lobel, professor of law at the University of Pittsburgh Law School, and I want to talk today about the problem of solitary confinement in this country. At any one time in this country, there are approximately 80,000 prisoners who are held in solitary confinement. A good example would be the prisoners held at Pelican Bay Prison in California, who number about 1,000, who are kept in small cells with no windows, locked up 23 hours a day, many of them for years. In fact, in 2012, 500 had been locked up in this kind of solitary confinement for over a decade. Recently, the issue of solitary confinement has gotten a lot of national attention. President Obama criticized the practice and said we should move to reduce it. Justice Anthony Kennedy, in a concurring opinion in a case, said that solitary confinement for a prolonged period of time can drive people mad, and that he invited somebody to bring a case to the court so that the court can address the constitutionality of this practice. I have been directly involved in challenging the constitutionality of the practice because I brought a case on behalf of the Center for Constitutional Rights challenging the prolonged solitary confinement of over 1,000 prisoners at Pelican Bay State Penitentiary. We argued that it was cruel and unusual and inhumane treatment to hold somebody in these small cells 23 hours a day, year after year, and in some cases decade after decade. In addition, in many cases, people are put into solitary confinement for minor offenses without any serious due process. At Pelican Bay, all of my 1,000 clients were put in because of some gang affiliation, which could have meant simply that they did artwork which the prison officials felt was gang-related, or that they had political literature that somehow the prison officials felt were gang-related, or they had a gang tattoo. They didn't have to have committed any specific misconduct, like assault or murder, to get put into solitary confinement. We as a society tremendously overuse solitary confinement. There is no need for this from a penological perspective. It seems obvious to me that it's cruel and inhumane, even though the courts have not thus far held it to be so. And there are various challenges, including our case, that were working their way up the courts eventually to the Supreme Court, for the Supreme Court to rule on the constitutionality of this practice. Just today, however, we had a major breakthrough in California, in that California agreed, and we filed the settlement today, agreed to dramatically change their policies with respect to solitary confinement. First, to reduce solitary, and second, to create some alternatives to solitary. In the reduction part of the settlement, they agreed that they will no longer put prisoners in solitary confinement simply because of gang affiliation. They will only put prisoners in solitary if they've committed some serious offense like murder or assault. And second, they agreed to limit the term for solitary confinement. At present, they give people indeterminate sentences in solitary, namely that you can spend year after year, and as I said, decade after decade in solitary. Now they'll only give you a determinate sentence for the specific misconduct that you've committed. Third, they agreed to review all of the people now held in solitary confinement for gang affiliation, and to send virtually all of them, or most of them, to the general population. And everybody will be sent to general population unless they have committed a serious offense recently. And finally, California grappled, and we grappled with California in terms of this case, as to what do you do with the truly dangerous prisoners who need to be separated from the general population. Most of the people held in solitary confinement in this country, I don't think meet that standard. I think they could be handled in other ways. But there's some people who clearly are either pathological killers or people who are very, very dangerous who have to be removed from the general population. And our position, which California accepted in part, at least for a model, a pilot program, is that they should be separated from the general population, but not isolated, not subjected to this draconian isolation of 23 hours a day in your cell, no contact visits, no phone calls, no ability to recreate with other people. California has agreed in part of this settlement to create an alternative to solitary, which would be a highly restrictive general population unit where people still would have contact visits, phone calls with their loved ones, educational programs, significantly more out of cell time, but it would be in small groups. It wouldn't be in a large yard like in the movie Shawshank Redemption, where hundreds of prisoners are milling around. It would be 4 or 5 or 6 prisoners recreating or having an educational program or engaging in some leisure activity, but in a small group, not in a large, unsupervised group. We think that this could possibly be an alternative to solitary, which could be replicated nationwide. And the key task in the movement against solitary, both in the courts and in the general public, is to come up with an alternative so that people don't have to be placed in this kind of draconian, inhumane conditions.